What's up, everybody? Welcome back into an episode of the Lawyer You Know podcast. And week 2 of Brian Walsh's trial is in the books. The evidence has closed. The defense rested, very interestingly. And we're going to get my dad's take on it to see what did he think about the defense's strategic decision? What did he think about the opening statement now from the defense attorney, knowing how the case in chief went, how the evidence ended up getting presented to the jury, and how each side changed or altered potentially their closing argument based on the decisions of the defendant and the defense attorney throughout this case. And then, of course, what does he think this verdict is going to be? How long does he think before we get a verdict in this case? A lot of people, including myself, thought we might have it by Friday night before the weekend. We didn't. Will we be getting a verdict Monday, or will it be a very long wait? We're going to answer the questions you had throughout this week and more. Let's get to it. All right, Dad. So the case is in the jury's hands, and they have been deliberating now for a couple of hours and have not made a decision, but we got the entirety of the case done in 2 weeks, thanks to the fact that the defense put on absolutely no evidence. What were kind of your overarching thoughts of week 2?
Overarching, there really were only a couple of witnesses that I would think were really important witnesses. You got a couple of people that got on the stand and just you got some videos, you've got some, I collected this, I collected that. But when you really boil it down, this week only had about 3 or 4 witnesses that I would say were really key witnesses that were important, that made a difference.
Yeah, we don't need to go through more Home Depot witnesses and people,
Right.
more dumpsters and him dumping things at dumpsters. We don't need to go through everyone that did a background of what step they did 1 through 4 of the DNA process. I did steps 1 and 3. I did steps 2 and 4. But I did think the DNA evidence and connecting it all was pretty important at the end. So do you want to start there talking about DNA?
No, we can get to that if you want to just start from the very beginning of the week. Yes, I think she was very important. The DNA expert was important. The other people, you could have put anybody up there to throw in the hatchet and throw in the hacksaw and do those things. But she added meat to all of those things that were introduced into evidence. But I think we should start with the medical examiner that finished up, because that turned out to be even more significant than I think anybody thought when that medical examiner testified. You and I know, disagreed on the medical examiner or the defense getting into the unexplained sudden death with the medical examiner. And I said, he's going to try to do it because, I figured this is one more expert. I just figured this was going to add to the credibility of whatever he was going to put on. However, I think we also discussed the fact that it was probably objectionable, and that the state could have objected to it, the Commonwealth could have objected to it, and might have been able to keep it out. And it had nothing to do with the prosecution's case. It had nothing to do with the direct examination of the prosecution. So it was well outside the scope of the direct examination. And he basically was putting on his theory of defense in the prosecution's case, when normally you're not allowed to do. So a good objection here by the prosecutor would have, I think, kept it out. I think the prosecutor was lulled by the opening statement into thinking that this guy was going to testify. So, why bother recalling the medical examiner? We can just get it done now. And this way we can save ourselves some time in the long run. This is a lesson to be learned by all prosecutors, that you don't sit around on your hands and waive objections, that when something's objectionable, you object to it. And they should have objected to this. And later on, it came to bite them, I think. I mean, let's face it might not make any difference. But I think that, in hindsight, they should have objected to it. They should have tried to keep it out, because think about it. If they had kept it out, where would they have anything to use in their closing statement about this sudden unexplained death?
Yeah, I think that not only was it objectionable for all those reasons, there was no factual basis for them to even ask any of these questions. Like, why is that relevant? You couldn't start asking this just because he's a doctor doesn't mean you can start asking about cancer. Like, hey, can you tell me about cancer? How does cancer start? How curable is cancer? Which cancers are the most curable? You can't do that, even though it might be true, even though it might be within his expertise. It's outside the scope. There's no factual basis. There's no good faith basis, frankly. And from my perspective, yeah, I think it was all completely objectionable, but they really have. A lot of people have said these prosecutors are not confident at all. To me, some of the decisions they made me feel like they were overly confident. Like they love this sudden unexpected death defense because they think it's, so stupid and nobody's ever going to buy it. And while that may be true, it's still like the best defense he could come up with at this point. And why let them even put this before the jury when I think they could have kept it completely out with good evidentiary arguments that they just didn't make?
I think the prosecutors knew it was coming. They knew that the defense was going to ask their expert about these things because in their redirect, it was obviously they prepared the witness for the redirect on explaining some of this stuff. Like, well, when you talk about travel, what kind of travel? Oh, it has to be long travel, like across the country, not just from Washington, D.C. to Boston. What evidence did you see? No evidence. Those kind of questions. But again, you really shouldn't have gotten to that. And I think you might be right. They might have been a little bit overconfident in this evidence, and they were lulled again by that opening statement into thinking, we're just going to go ahead and go for it and let it all hit the wall, throw it against the wall and let it all hit.
Yeah, and that's to me, a good response is important, a good redirect is important, but you know what's better than a good response? Not letting them make the argument at all. Not even ever letting it go to a jury. If you can remove it completely, that's better than having a good response to whatever it is that they're going to try and throw out in front of the jury.
Right. So it again, now I'm sure they wish they would have objected.
All right. What else do you want to hit?
We had surveillance, we had gathering of hydrogen peroxide and, all that stuff. But the only other person I thought that was important was the security guard. The reason I liked the security guard's testimony is because he said that Mr. Walshe got emotional on the phone. And that's the only emotion that we saw during the entire case regarding this guy. He was cold. He was calculating. On the videos, he was confident. And again, I don't understand why in some videos he wear a mask and in some he'd look into the camera and fix his hair, but those kind of things. But he was emotional. So I think I would have used that to say he was, tried to be act where he thought it would do him the most good and the way he thought it would do him the most good. And on that phone call, he thought it was to his benefit to be emotional. So he was emotional. That's the only key thing I think from the security guard that I got.
Yeah, I thought he was fine. Yeah, I thought he was a fine witness. Again, I don't think we heard from a couple Tishman Speyer employees, and I think they continued the same narrative that, Brian, and it shows like what a psychopath Brian Walshe is, that he was calling all these people pretending to be looking for her when the defense clearly admitted throughout the trial that he disposed of her body.
Right. So, but that's about it for that day.
Okay. Then let's move to day 2, I think or day 2 of the week, day 7 overall, which was the DNA day.
Okay. Well, no, we got the Teresa McCarthy. I think you skipped a day.
Oh, okay.
Yeah, because you got Teresa McCarthy. That was the employers, one of the people there at the office where she works that got the call, told us about the salary. And then the defense in that case went into how many sick days has she used. Legionnaire's disease was in a couple of buildings. And she had never brought up the divorce. So again, that was her.
That was the same day as the security employee.
Oh, okay. I messed up my days then.
No, that's fine.
You're right. And then we've got the crime lab. I think the knife above the refrigerator was one of the things that I thought was pretty important. And then the basement blood, the hair, and that bleach destroys DNA. They got that out with that person. So, okay, you're right. It was the same day because that's got my notes. So that was it for that day.
Yeah. And then we saw the prosecutor connect that in closing, like there was some premeditation here. he was figuring out how to clean things, figuring out how to cover up things. Some of the things he already had in his house, some of the things were pre-planned potentially based on some of the searches, and then some of the things after were very clearly including the M word in some of his searches, which we'll get to when we get to closing arguments. But yeah, the defense really wanted to fight that knife and try to kind of use it as a, oh, please, they cared about the knife and then they stopped caring about it. But we'll save that for when we get to closings. Okay. All right, so then what about the DNA?
Okay, that was Miss Salem. She was very important, but she could have been better. I guess that's the way I would put it. When DNA started, and I was around when DNA started, and I tried cases, we were just amazed that the number was like 1 in 30,000. So they were able to match. So only I remember a cross-examination in one case where 1 in 30,000. Okay. So that meant, we live in Pinellas County, and there's about 1 million people live in Pinellas County. So that means there could have been, how many people just in Pinellas County, if it was 1 in 30,000, that could have matched this DNA profile. That was the cross back then. Now, I remember that I wrote the number down, octillion, which is 27 zeros.
It's crazy.
So things have come a long way in DNA. So you really can't, it's kind of tough to cross on that. But what they didn't do is they didn't really get her to say, this is the guy. And I thought they really could have done that, but they didn't need to. She really did say it in the statistics, but I would have gotten her to say, this is the guy.
Well, especially because the defense wasn't objecting, number one. Number two, in closing, again, the defense even said, yeah, we agree. It's Anna Walsh's. They found Anna Walsh's DNA on this stuff. Yeah, we agree. They found Brian Walsh's DNA on this stuff. They weren't fighting that. So the fact that they were saying like, oh, is this many times more likely that it was Anna Walsh or whatever? It's like, why don't you just say this is Anna Walsh to the whatever octillion, whatever, this is Anna Walsh's DNA. And right. We're 1 in octillion. It's just like crazy when they make it more confusing than it has to be. I understand you have to give that as a background and as a basis and as a foundation. Once you give that, then you can ask them the simplified version of the question. And I don't think they did that enough.
No, I don't think they did either. And then the cross-examination, cross-contamination was the cross-examination on this. But again, that's foolish considering their opening statement and considering the position they taken during the trial to think that there was cross-contamination of these items. So, they were kind of inconsistent in their defenses as they were going through the trial. And they really didn't have a good focus. If they really were focusing on certain things, it would have been better. But sometimes I felt like he just had to get up there and ask cross-examination questions because that's what he felt like he had to do when he really didn't have to do that, especially on this DNA, I think.
Yeah, I think part of it, he was trying to keep it on, he would focus on like the slippers because they had that before. He didn't go to the store and buy the slippers. He didn't search it after she had already passed. So he was maybe trying to differentiate to some of what they had before and after. But also, I think he couldn't help himself. And as I've watched this trial, I'm thinking to my head, would it have been better just to say, you guys can't prove that he did this? You can't prove that a homicide here and just go with the you can't prove it defense versus the sudden unexplained death? I think that would have been better maybe in some aspects. That's what some of this cross reminded me of is if you were going to go with that, then I think it would have been better cross. But because you've made certain admissions and then certain comments that seemingly were factual that you were going to prove, it didn't really make a lot of sense. Whether I'm shopping for Christmas presents for somebody else or just looking for something for myself for some of the holiday trips I'm going to be taking where I know it is going to be cold there, I keep coming back to today's sponsor, Quince, because their outerwear lineup, especially for men, is just my absolute favorite. And their prices for the quality that you get, you just can't beat when you look at other stores, whether it's in-store or online. So I keep coming back to this website. I keep using my own code every time I go there, my own link every time I go there because I really love the product. There's never been something I've gotten from Quince that I haven't loved and put into into my wardrobe as a staple, whether it's golf shorts, whether it's the corduroy pants that are kind of like a green color so I can really wear them for holidays, whether it's the bomber jackets that I don't only have in the cognac color, but I also have in black. And my wife steals it sometimes as like an oversized jacket. I really love Quince. That's all I can say. So get your wardrobe sorted and your gift list handled with Quince. Don't wait. Go to quince.com/LYK for free shipping on your order and 365-day returns. Now available in Canada too. That's QUINCE.com/LYK. Free shipping and 365-day returns. Quince.com/LYK.
I think it also comes down to this was tough.
Yeah.
It really comes down to this is a tough case. You had tough facts. Yeah, the evidence and everything that the prosecution has in this case, it was kind of tough to have a consistent message through all of the videos and everything that he had done. So they had a tough road to hoe. This was a tough case for the defense.
Yeah. All right, who's the next witness you want to talk about?
Well, the next one, I guess we can move to the next day. Okay. Frankly, I don't have anything else that day.
Yeah, their DNA was most of it.
Yeah, and that would be the friend.
He was a big witness. I think he was a really important witness.
He was.
Jem. And kind of both sides seemingly liked him and thought they were going to get good information out of him.
Yes. He was benefit. Both sides thought he was important. And you can tell by the way they questioned him. The prosecution, there were some really interesting things. One is Mr. Walshe discussing how much he made and how much his wife made with him. I thought that was kind of a strange conversation that they had, I guess, a dinner or a party, whatever they called it when they just were over at the house together. This guy said there were no problems, and Walshe told him he'd misplaced his cell phone. And I thought that was an important statement, especially toward premeditation, I think. Work emergency. I just think that, this guy was really good on showing that, number one, that they had a good relationship, that he was over there as a friend. He was a friend to both of them, even though I thought this was interesting, even though she had left his employment to go work on the new job, he was still a good friend. He would still come over and spend time with them. The cross, to be consistent with their theories, put down that she had a crush on him at one time, which again I thought was important. He never saw them.
I thought that was interesting. Yeah. I thought that was interesting.
Yeah, because the theories were, she has a lot of crushes, and she's upset because he's not more jealous than he is. That's a theory that they put on. And here's another person she had a crush on. So crush to her must have had a different definition than maybe we would have had. He saw a lot of love. Now, on the redirect, though, and I wrote down here, and I know that he did say a crack in the relationship. You remember that? In the
yes. Well,
yeah, that was, and he used the word marital problems, but the judge jumped on that.
Yeah. Did you think that was weird? Like she wouldn't let him characterize the conversation, but if you're allowed to testify to that hearsay based on Anna Walsh's state of mind because she's an unavailable declarant because of the defendant, he made her unavailable. I feel like you should be allowed to say they had marital problems. Like she was talking to me about their marital problems.
I guess the argument is that that's a conclusion you're drawing from the statement.
Except that she said it.
I don't know if she said marital
Well, he said the exact words, but even if you can paraphrase, I don't know. I think that was a little tick-tacky, and the jury clearly got what he was saying.
Right. Yes. Yeah.
But I thought, so here's what I thought. Here was my assessment of Jem. I did not think he was overly bad for the defense when the Commonwealth directed him. It's like they put up this witness. He could have been a star witness. But then I thought where he became a star witness for the Commonwealth was during cross. She opened up that door of, there was a crack in the relationship. Yeah, you don't really know people clearly. Yeah, he called me and it was kind of like a very strange conversation. I was like, why didn't I know about this? And then in redirect, they went into it even more about the crack in the relationship and how just things were not maybe what they had seemed, which it didn't feel like that after his direct. I feel like he got so much worse for the defense after cross.
Right. Well, another thing he said was when he got the call that she'd been missing for 3 days, I guess when he got the call, he thought that was a little strange. That she'd be missing for 3 days before he would call him, and his voice was not panicked. So again, this came out in cross that his voice was not panicked, and that it took 3 days for him to call. So that certainly hurt the defense.
Yeah.
And then we've got the I thought the parole officer, which came after that. You ready to go to the parole officer?
Yes, I've already done breakdowns of every single one of these witnesses.
Oh, okay.
The point of the podcast is for people to hear what your thoughts are for these witnesses. And I will tell you, the chat said the parole officer was one of the main witnesses that got a lot of people to premeditation because they thought he was planning ahead with some of the things he did with the parole officer.
Absolutely. That's why I brought the parole officer, because I thought the parole officer was significant.
Okay.
Because number one, juries are going to view the parole officer as law enforcement. Secondly, the parole officer is basically someone that, not necessarily a neutral because she works for the government, but she's someone who is honest. They didn't view that parole officer as anybody that would be coloring her facts or her statements. So I think she was significant, and they believed what the parole officer said. In that case, number one, he had home confinement, but he could do certain things under home confinement. But he absolutely knew what he could do. I mean, I don't think they could have gotten into this more, but when you become on home confinement, you're sat down and you have to sign one document after the other, detailing in writing what your home confinement consists of and what you can and cannot do. There is no question in any home confinement individual's mind about what he can and can't do. And yet, we see where he violated home confinement. And he violated it beforehand. So that's, again, premeditation. Why did he do that beforehand? The other is he could not go to a restaurant. That's not something that he could do during home confinement. Yet he makes a reservation to go eat at a restaurant. So I think that those issues were important to the jury in seeing that, this guy was not obeying the rules, and he must have been, I think, he must have been planning something. Why was he doing this? Why was he acting like this? And why would he violate home confinement? What was he trying to do?
And that's why he lost his phone, because he couldn't reach out to them. And that's why he couldn't reach out to them. And this stuff happens. And yet when you see, and that's the other thing, where there are some people, in the chats who are, trying to presume him innocent and give benefits of the doubt. But that takes it to another level when you see a guy driving to apartment complex and store an apartment complex to throw trash bags in different dumpsters and trash compactors. He is literally not allowed to even do that. Like, just doing that is violating his home confinement. So he is making a conscious decision to do all these things. Why is he going through all this trouble, right? Like, those context clues are important. That consciousness of guilt is really important, and the jury did get that instruction.
Okay. Now, it's interesting that your listeners thought the parole officer was important too. I'd wondered if people really picked up on the significance of what she had to say.
I think it was obvious. I thought she was one of the best witnesses, and she's a professional. I mean, not a professional witness, but she is a professional who was a witness in this case. And to me, that made complete sense that he was also hiding it from her. But if you're going with the defense's theory, it was all just to cover up, the sudden unexpected death, because he knew everybody thought it'd be him. And so that's why he disposed of her body, which, okay.
All right. Next, we have Miss Kirby.
Yes.
Now, Miss Kirby, I thought also was an important witness. Again, she's one of the handful of important witnesses, and I thought she was an important witness. I thought it was significant that she knew that Brian Walsh's mother had a psychic say that Mrs. Walsh was having an affair.
Right.
So, I mean, that there is so much logic behind her also telling her son that, which she obviously did, that it helps the state's theory tremendously, because there isn't a lot that really, there's a lot of innuendo and a lot of assumptions that the state wants to, the Commonwealth wants the jury to make, but this is not one they have to make an assumption. This is if you again psychic, but still, the mother of the defendant is saying she was having an affair. My psychic told me.
Yeah.
And I think that was significant.
Yeah, to me that didn't matter. I was like, whatever. I didn't even care about that.
Oh,
There's
I
so many
thought
other
so.
context clues and so many. No, I'm just saying from my perspective, there were so many other things happening that whole motive of did he know about the affair? I just really don't think they proved it, even though they didn't need to. But what was also big is throughout the trial, everybody in the chat saying the mom hired a private investigator to look into the affair. They knew that never came out. That was never part of the evidence. So that's not something the jury's going to consider. So this was about as close as they got to that.
Right. And then she is the one that clearly said the marriage was stressed.
Big time.
And that he should take responsibility and go to jail. I mean, you kind of think about that for a minute. Yes, you kind of think about that, and you think, here's your wife, and your wife's telling you, take responsibility, go to jail. That's something that might set you off.
Yeah.
That's something that could definitely set you off.
Yeah, and that's the point. I think she did a good job of giving the jury, like, this life, he was depressed. They weren't intimate for over a year. Like, all these details she brought out. It's like, you can understand why this guy could have snapped and lost it on Anna Walshe. It's not that far-fetched. Even though I don't think the financial motive was great, I don't think they proved beyond a reasonable doubt that he knew that she was having an affair. Like, I don't think they proved any of that we can really, put our finger on what the motive was. But it's not a far reach to think that their life was in turmoil and everything was slipping away from Brian Walshe, and he would do something just crazy like this to try and fix it somehow, some way. That's not a far stretch for me.
Kirby did give the defense something, though. She never knew about the affair. Right. And so here's, I guess they're characterizing her as a best friend or a very, very close friend, and she never knew about the affair. So I thought that was a gem for the defense.
Yeah.
And that's about all, significance on Kirby. Mm-hmm. That's what she gave him.
Yep. Okay. So then there was a stipulation that they read about the federal case that he pled guilty. He was seeking probation. The government was seeking prison time. He hadn't been sentenced when all of this happened. What did you think about the stipulation that they read that into the record? Because both sides were using that federal case as a motive. The defense was using it as a motive as to this is why he was all freaked out. This is why when he woke up and she was dead or whatever, he saw her dead in the bed. That's why he tried to cover it up because of the federal case. That was the only thing stressing their marriage was the federal case. Nothing else was stressing their marriage. And then obviously the Commonwealth was using that as one of the motives because he wanted to keep the kids. He needed the money. He had to pay this $400,000. So they were both kind of using that federal case. So they stipulated for this to be read to the jury.
I think that it was the right thing to do from both sides. It was kind of ridiculous for them not to actually explain that to the jury, considering they're both using the federal case in different ways, especially if you take a look at the defense opening and how they were using the federal case as a way as to why he is talking about money and why he's talking about finances and he wants to protect the family finances and why he might be talking about divorce. These are all things that revolve around the federal case. So it was essential for the defense, prosecution also. And again, the jury already knows the negatives about the federal case by the time they did the stip. I mean, they're all already know that it's this guy is already under a federal indictment and he's under home confinement and he had a probation officer testify. So, it really didn't hurt anything, but it probably just helped explain it to the jury. I think it was necessary.
I agree.
Yeah.
Then we had the JOA arguments, which was not a surprise. The defense focused on premeditation. What did you think of the defense's argument?
I think, frankly, they should have carried that. I think it was the right argument to get rid of M1 so that they could just go the jury to M2. It was the right argument. I mean, of course, they're not going to win,
right?
But it was the right argument. But frankly, as we get to their closing, it's an argument they should not have abandoned. It's an argument they should have kept up. But they only made it to the judge, and they should have kept it up. They should have expanded it.
They made it a little bit to the jury, but not as much as they should have. But and I actually thought
you could have easily missed it. You could have easily missed it in their closing.
Yeah. I think the Commonwealth's response was actually not good and did not show a lot of premeditation. Personally, the more I thought about it, but that was just in the JOA arguments. Then we get to the closing arguments where Tipton gave it, the male lawyer gave it for the defense, and the female lawyer gave it for the prosecution. Defense goes first in the Commonwealth of Massachusetts, and the Commonwealth goes second, as opposed to in Florida, the state goes first and last. But what did you think of the defense's closing? This time of year, we're buying presents for all kinds of people, not just the ones we're really close to that are our family members, but sometimes people we don't know at all. And today's sponsor, Aura Frames, can be the perfect gift for either, because everybody likes frames and has loved ones and people's pictures they want to put up, even if they're not pictures of you. And Aura Frames provides that in such a simple and easy way. You can upload unlimited photos and videos if you just download the Aura app and connect it to Wi-Fi, and you can do it straight from your phone. And if you're sending it to one of those people that you do know and love, you can preload pictures on it. You can send it with a special message, and it can be sent in a premium gift box with no price tag. It doesn't get much better than that. For a limited time, save on the perfect gift by visiting auraframes.com to get $35 off Aura's best-selling Carver Mat frames, named #1 by Wirecutter, by using promo code LYK at checkout. That's auraframes.com, promo code LYK. This deal is exclusive to listeners, and frames sell out fast, so order yours now to get it in time for the holidays. Support the show by mentioning us at checkout.
Well, rather than, and again at the end, I'll probably give an overriding comment. But going through their closing, he started off right. He started off with the affair, money. He started off with the three-pronged Commonwealth attack on motive. And I thought that was good, because their motive was one of their weakest aspects of their case.
Agreed.
And so he started.
While we know you don't have to prove motive, he did make a clever wordsmithing of, without motive in this case, they can't prove X, Y, and Z. Without motive, it must have been a sudden unexplained death. He tried to make motive something they had to prove, even though they didn't really have to prove it.
Right. You try to make it an element of the case.
Exactly.
And which, again, I thought that was good. Give him that, that's, hey, you got what you got. So he had to go ahead and attack the motive. He certainly can't attack their physical evidence, because, you got the DNA, you got hatchets, you got hacksaws, you got all of that stuff. So you got to attack motive. And that's where, when you really get down to it, that's where his opening statement, I don't want to say benefited, but without an opening statement like he gave, he could not have given this closing argument. The jury would not have understood the closing argument without that. But because in his opening statements, he was able to explain, this is what he was thinking. This is what he panicked. This is all this stuff that he had. She rolled off the bed. She saw her there. All the facts that he gave in that opening statement. Without that, he could not have given a closing statement at all, at least one not even close to this one. Because again, the jury would not have understand, what the heck are you talking about? So he used the opening statement in that way.
So knowing that, what was your thought of the fact that he did all that in opening, didn't call Brian Walshe, didn't call an expert, didn't present any evidence of sudden unexpected death, didn't present any evidence of what that Anna Walshe was in the bed, that she was nudged, that she rolled out, that Brian Walshe freaked out, everything Brian Walshe was thinking, everything from Brian Walsh's perspective that we heard factually in the opening statement?
What I think about that, or what I think about the decision of Brian Walshe not to testify?
Well,
what is it?
The whole thing. What was your thought? Do you want to do it after we do closings, or
no? This is fine, because this is a question I anticipated.
Right.
This is one that, because when he said he wasn't going to, or they said there was no defense, I had to sit back and say to myself, there really are, and I know that you and a lot of your listeners kind of focused in on certain decisions. How do you make that decision not to testify? But there really is a lot more into it. There could have been many reasons this happened. I've said many times on this show, trials are living, breathing things. When they got to the point of the state of the Commonwealth resting, when they got to that point, it might have been a different case than they were anticipating when the case started. And it might have been, excuse me?
You can go finish your point, but you cannot act like you don't know that that's a possibility when you're giving your opening statement. That's the point of being a criminal defense lawyer. You know it's living and breathing. You know he may not testify. I don't care what any defendant tells me before a trial. You know that point comes. And probably a lot of times if they ask us, we'll be like, you probably shouldn't testify. So knowing all that, you're still making conscious decisions in opening statement to say you will hear him testify to this, that he nudged her off the bed. This is how it happened. I think it's inappropriate personally.
I don't. I think that if he, in good faith, when he made that opening statement, that he believed that, this is what the path they were going to take, I don't see anything wrong with that opening statement at all.
That's not what you said when we broke down the opening. Because I asked you if Brian Walshe doesn't testify, would you have a problem with that? You said, yes, I would.
Yes, but he had to know. What I meant was, I can explain myself. What I meant was, when he gave the opening, if he knew Brian Walshe wasn't going to testify, yes, that would have been an improper opening statement. But if he believed when he made that opening statement that Brian Walshe was going to testify, then there's nothing wrong with that opening statement. It was ethical,
but that's fine.
If he believed in good faith that Brian Walshe was going to testify and that evidence was going to come in, I don't see anything improper with that. When it got time for Brian Walshe to testify, they might have said to themselves, you know what? We're not going to get any, it's not going to get any better on premeditation than it is right now. That him testifying is only going to make premeditation worse. And if the only thing we're going to go for here is M2 and try to save him from an M1 sentence or M1 conviction, then him testifying would be a mistake. So let's change our strategy, which they certainly are allowed to do. Let's change our strategy at that point and tell Ryan, you know what? You're better off not testifying. We're better off not putting on a case. Now, that is the lawyer making a recommendation to his client after hearing the evidence during the course of the trial and changing his strategy. However, on the other side of the coin, Brian Walshe may have decided he didn't want to testify. And he may have said, after hearing and seeing all this, and they're going to ask me all these questions about all this stuff I did, I'm going to look like an idiot up there. And maybe he was smart enough to realize that it had been a stupid decision for him to get up there and testify and be cross-examined on all this stuff. Or there's a third possibility. And again, I'm just totally speculating. After it was all over, Brian Walshe may have said something to his lawyers, where his lawyers might have thought it might have been unethical to put him on the stand to testify. So you got three ways. You got the lawyer changing their mind or their strategy, which is totally acceptable. You got the defendant changing his mind about whether he wanted to testify, or you have an ethical conflict by what the client may have told you versus what he would testify to on the stand.
Okay. I have no problem with Brian Walshe not testifying. I think that he would have gotten destroyed on the stand. I never would have even planned on having him testify. But once you give that opening statement, you're not supposed to. Like the way the rules are as a lawyer, you are not supposed to really say what the defendant is going to say unless you're sure that they are going to testify. And the judge was not happy about it. You could tell the judge was not happy about it, and she was going to give the Commonwealth more leeway than they ended up taking in closing. I would have used more of that rope that she was giving than they did, number one. I'm positive you would, regardless of what you're saying here. I'm positive if you were the prosecutor in this case, you would have made sure the jury understood that she wasn't nudged off the bed. None of that facts came into evidence. Nobody testified to that. Nobody testified to anything happening to Anna Walshe other than her tissue and DNA being found in dumpsters spread all over the county. That's the only thing anybody testified to in this case. And so the fact that he did that, and I don't think he should be disbarred or sanctioned. That's not the appropriate remedy, because I think there are natural consequences to it. And the natural consequences to it, I think, are the jury realize it's BS. That's what I think. And I think that's also why, as a lawyer, you usually don't want to do things like that. You usually don't want to say that you're going to hear X, Y, and Z when they never hear it. And then, to me, Tipton was tiptoeing all around that and did not seem as confident, did not seem as engaging in closing argument as he was in opening statement. I felt like he believed his defense in opening statement and he didn't believe it anymore in closing argument. That's what it felt like to me. And those, I think, are the natural consequences to doing something like that. And I think it made him lose his confidence and feel like he lost his credibility a little bit with this jury based on that opening statement. That's the vibe I got.
Well, again, and we'll talk about the prosecution's closing, but the defense, you're talking about, I think the word I would use is he felt like he was a little off balance in his closing statement, because he had developed a theory that he was going to do. That was from his opening. That was the theory. That was what he was going to present. And he was going to present that at his closing. I'm sure that he had to totally change his closing. I don't know when the decision was made that he wasn't going to testify, but once that decision was made, it could have been made the night before. It could have been made that day. He had to totally change his closing. Number one, he had to change his closing in order to comport with the fact that he couldn't say a lot of the things that he said that Brian Walshe was going to say. But on the other hand, he also had to do it. He had to dance. It's uncomfortable in a closing to sit there and have to dance and be careful about the words you say and how you say them, because you don't want to be held in contempt by the judge because you violated her order. So he had to really dance. When you have to dance like that, you're uncomfortable. It doesn't flow like it should flow. And yes, I agree with you that he was in a bad position at that point, and his closing did not flow very well, and his style points go down. Yeah.
So what else did you think about the closing? I kind of interrupted you when you were talking about.
Okay.
Yeah, go ahead.
All right. He kept, he used some of the things he did in cross-examination that really weren't that effective, like, context matters. Well, you know what? If I was a juror, I'd say to myself, well, context matters. I know you don't have to present anything, but in your cross-examination, you didn't ask him about any other searches or any other text messages or things like that that would show that he consistently does searches about Clorox, but he goes, context matters. And, he didn't ask about context. He just complained that there was no context. And his searches, I think he could have done a better job, because you know what? I think his searches and the way this guy, Brian Walshe acted, showed confusion. When they talk about confusion, and he tried to show that he was confused and panicked. Well, he was really kind of erratic in the way he was acting. Sometimes he had a mask on when he would go into these places, and gloves. Sometimes he didn't have a mask and gloves. Sometimes he would search things a certain way and search things other ways. I think the guy, you could have argued that he had some confusion, but he didn't really deal with that very much. But I think he could have done a better job. And so when it comes down to it, I think that it was a closing argument where he should have probably stuck with no premeditation. He could have emphasized that more. No evidence of any premeditation, and no intent. He really could have. He really could have stressed that a little bit more, because I really think that's his best argument. But he kind of waived it. His best
argument is to get it to second degree. But maybe his client wasn't on board with that either. Maybe he kind of wanted the Hail Mary, all or nothing type of argument. But
and like with the medical examiner, going back to the medical examiner, well, you don't have a body, so I can't tell you anything about this sudden unexplained death. I have no idea if this has anything to do with this case at all. Mm-hmm. So stressing that in your closing, I just didn't think was effective.
I agree. It's like, that's why he cut up the body and threw it around town. Like, that's why. So you could make this argument. That's what it felt like the common sense response would be. What would you grade it on an A, B, C, D scale? The guys at True Classic started with a simple mission: to bring premium, comfortable clothing to the masses, because looking and feeling great shouldn't come with a designer price tag. I'm wearing my True Classic today, which is an absolutely perfect shirt for the mildly chilly winter day here in Florida. And I'm getting it for so many different people as their Christmas gifts in my life this year. And they are staples they can wear with almost anything in their wardrobe, evidenced by the fact that I wore a True Classic black tee, just a plain black tee, in our Christmas card picture this year. So of all the t-shirts I could have picked, or my wife could have picked, because it was really her choice, we went with True Classic because it looks awesome, the material's awesome, and it's just a plain black tee that goes with any theme that you could want or your wife could want for those Christmas card pictures or other events. So skip the guesswork and the overpriced designer stuff. Give comfort, give confidence, give True Classic. You can find them at Amazon, Target, Costco, and Sam's Club, or head to trueclassic.com/LYK to grab the perfect gift for everyone on your list. Thank you to True Classic for sponsoring this video.
I might give it a D.
I would only expect because it to be a harsher grader than me.
Only because it was in no way persuasive.
Yeah.
That's the key to a closing argument is you're not going to win or lose. I mean, people think, oh, great closing argument. You're not really going to win or lose on a closing argument, but your closing argument needs to be somewhat persuasive. So you get the jury to think certain things and think a certain way, because he really didn't get them to think. Again, they're going to think about premeditation intent without that closing argument, but by ignoring it, that's why I give him a D.
Okay. Then we get to the Commonwealth's closing.
Well, the Commonwealth closing, first off, I think it was a wise decision to have the female prosecutor do the closing. That was neither one of these prosecutors are what I would call an exciting courtroom presence, but she was more exciting than the male prosecutor was. So I think she had a better presence up there at the podium.
I like the male prosecutor better personally, but I do think she did a good job on this closing, even though she read the whole thing. But I think the facts they strung together, I think it was well done. It's well put together, I would say.
And you and I talk about that reading. And I remember, what was it? The Johnny Depp trial.
Mm-hmm.
And I remember that one of the lawyers read their whole closing. And I remember we criticized that. And I remember that a lot of the people that were listening commented that they had no problem with the reading of the closing argument.
Mm-hmm. I think it depends on the case. It depends on the case, the facts, and everybody loved Camille Vasquez. That's who did it.
Maybe.
I mean, that context matters, but generally speaking, I think if the same exact person gave the same closing, reading it and not reading it, everybody would say that not reading it is better, as long as they could present it the same. But if you're going to miss half of your facts by not reading it, then you should read it, because getting the right facts and arguments out is more important than just the presentation.
Right. So I think that she had a good presence up there at the podium.
Okay.
She started it with a little bit of emotion, at least, so that was good. And then she went through some of the facts and some of the things. Actually, one thing that I didn't pick up on that I thought was interesting is in one of his searches, he refers to it as a crime scene.
Mm-hmm.
And I thought that, you know what? That's something I would have really emphasized. This guy called it a crime scene. Well, if someone falls off a bed and they're dead, It's not a crime. But when he did his search, he called it a crime scene. So I thought that was a good reference by her to refer to that as a crime scene. And that's the way he referred to it. I like the 2 days of unavailability that he created, allegedly created with the phone. The fact that she emphasized the children's involvement and how he involved the children and how he made statements about the children, because no jury is going to like that. And I would have done probably more clip playing. She played one clip, if I remember right.
She played more than one, but yeah.
Was it more than one? Yeah.
Of his police interview.
Oh, I would have played some clips of the Lowe's or Home Depot with him going around, with a list. He had a list and going around with that list. I would have played some clips of him going around shopping with the list or shopping with his children for stuff in order to cut up the mother. I would have done that. She made a good argument about, we can't have a body because who's responsible for us not having a body? He's responsible for us not having a body.
Mm-hmm.
And that's an important point for the jurors to understand, is how can you let somebody, so all M people have to do is make sure you can't find the body and they're going to get away with it.
And that's a stronger argument than people might understand.
Right. She also, let's see, She emphasized how many times he used M in the search terms, which again, these are all really, really important. So I think she presented a calm, well thought out closing. She was tried to be organized. It's a style difference, but I think that she probably could have done a better job of, and she did. I know I'm not finishing my sentence. She did do a chronology in a way, but I thought she could have done a better job of a chronology with the search terms. And you and I argued about that that search that he did before January 1st or before the 31st, about where he would email and say his wife's name and was dead.
Oh,
remember that
the December 25th search is when she missed her flight. Yeah.
Yeah, she did. But she didn't mention that. At least I don't remember her mentioning that.
I don't either.
In her closing. So I guess she didn't think it was significant as I did.
But she did. I thought the way that she, here's another thing I think the defense just completely missed the ball with. This was one of the biggest mistakes in the closing to me. When he said, how to dispose of a body after M was not the first search that he did. If he killed her, that would have been the first search. Obviously, I was like, that's the dumbest thing I've ever heard, because number one, he did do that search just a couple hours later. And number two, if he found her dead, the first search would have been, what do I do if my wife's dead? Or how do you know if somebody's dead or alive from a heart attack? Or how do I resuscitate, or something that would have been along the lines of what your defense is. So he highlighted how bad their defense is. He highlighted how bad the search terms were, and he highlighted the fact that he did search the thing that you admit somebody would search if they killed their wife and were going to chop them up. You just admitted that that's what somebody would search, but he didn't search it first. He searched it a couple hours later. That was just such a huge misstep.
Right. And again, she did emphasize, what do you do if you find somebody like that? And that was, obviously a big point. And the jury, again, the jury is going to look at that. Juries they're people. They're everyday people. And they're going to think, what would I do if I found my spouse, rolling off the bed and laying on the floor dead? Would I do what this guy did? Would anybody do what this guy did? And the answer is no. And then the other thing is, I think is going to be key, is how do you love your spouse. That's the whole thing of the trial, is that they were really in love. How do you take a hacksaw and saw off their arms and legs or whatever he sawed off? And how do you take a hatchet to your wife whose body is there that you really love? I don't know how the jury is going to reconcile it.
They're definitely not going to let him walk. I mean, I can't imagine they're going to let him, because they don't know if he's going to prison for anything else. So from their perspective, it's like, this is on us. What decision are we going to make? Which kind of leads me to the judge's definition and the difference between premeditated, intentional homicide versus second-degree depraved heart homicide. What did you think about their explanation and the jury instructions in Massachusetts?
I think they were good. I think the judge did a really good job. I like the fact she did it before their closing arguments. I think that's also is really good. What I think people don't realize, and when I was a prosecutor, I had 2 murder cases where I convicted both of them. And it was a question of, the premeditation was a question. And here on one of them, I argued between the first time that they stabbed him and the second time that they stabbed him, they had time to reflect. Maybe that first stab was something that, you couldn't control yourself, but you take the knife out, and before it goes in that second time, that's enough time for you to reflect on what you're doing, and that's premeditation.
And if you want to take the next step, that's actually going to intend to take the life. One stab might not, but you keep stabbing them and you have that intent. Yeah, I did like how she talked about the timing, how it can be mere seconds, it can be minutes, it can be hours, it can be days. And the defense objected to what they called the timing part of that instruction. And she said, no, this is the standard model instruction, which is how it is here too. And everywhere, really, premeditation does not have to be a specific period of time.
And the other case was a shooting case were shot once, they actually shot him 5 times. And I said, that's plenty of time to reflect on what you're doing when you're putting 5, you have to shoot somebody 5 times. That's plenty of time. So that's all it takes. That's all it takes for this reflection that they're talking about. The problem they've got is how does the jury going to think, how did he kill her? How did he kill her? Did he kill her with a knife? Did he kill her with a hatchet? How did he do that? Although I guess he bought that afterwards.
Bought the hatchet afterwards. So it'd have to be
right.
the kitchen
knife.
Strangle or, whatever.
Right.
There's because you got the broken teeth. Maybe he just literally beat her. I mean, there's a million different ways that he could have killed her, but I agree with you. The fact that he dismembered and disposed of the body without them finding the body, which is also a very weird thing. They found all this other stuff, but they never found the body. That's very strange to me. And I don't know if he got lucky because they hauled it away, if he buried it somewhere, who the heck knows. But he might have saved himself from premeditation by disposing of the body. But at the same time, because he admitted disposing of the body and lying to police, the judge can tack that on consecutively, potentially, to a life sentence if he gets convicted of second degree, which we'll talk about, kind of how all that works. But I guess we can talk about that now. So first degree is life without parole. Second degree is life, I believe, but you can get parole after maybe 15 or 20 years. So if she runs let's say another 20 years or 10 years on top of it consecutively, if you were going to get paroled for the M2 charge, would that tack on more years after that? I don't even know how that would work. I've never seen that happen, practically speaking.
You mean consecutive?
Yeah. If she ran consecutive.
Yeah.
So if you get paroled from the murder 2 charge, then you'd have to do the other 10 years.
No, you wouldn't get paroled. You'd stay there when you'd finish the one sentence, and then you'd stay for the second sentence.
Right. But you would technically have been paroled on the murder 2 charge.
You could have been, but I think at least, but you'd still stay there. They wouldn't let you out. Yeah. You'd still stay there and serve your second sentence.
Yeah. So the judge can make sure that, it's no good, which is frankly, to me, I'm fine with that, because you shouldn't be able to just chop up the person that you killed and then, that saves you some time or saves you an argument or whatever it may be. So that doesn't really bother me.
Well,
go ahead.
If I was this judge, and he came back with murder 2, there's no doubt I would put this guy in for as long as I possibly could. He never deserves to be back in society. A guy who would do this never should be back in society.
Could not agree more. Which leads me to, and again, people can say whatever they want, like presumption of innocence, which obviously we're big proponents of. He has admitted to lying to police and disposing of his wife's body. So
and the fraud. This guy.
Yeah, exactly. And the fraud too. Yeah. Okay. Yeah. But the jury has it now. Okay. What are your expectations as far as a timing of the verdict?
My guess is Monday. We would have a verdict.
Would you expect it Friday night?
No, I do think that. I think that they're back there fighting about murder, M1 or M2.
Yeah, that's what I was going to ask you. So what do you think the big debate is? Do you think it's just between premeditation and intentional? And
there might be, heaven forbid, there might be one person in there that could not convict because there's no body.
Yeah.
I mean, there are some people that believe that, there is no body, so you cannot convict. But there are plenty of convictions where there is no body. I mean, it happens all the time, all over the country. But it's possible that there's one person on there that just couldn't do it.
Which is why jury selection is so important, and they should have struck every juror that said something like that. Like, I would never convict unless I had a body. Like, those are questions you can ask in most scenarios. I don't know if this judge allowed it, but in most scenarios, you're absolutely allowed to ask that, because that's something that's not following the law, because that's not what the law says. The law doesn't say you have to have a body to have a crime, just like you don't have to have a motive to have a murder. So when it comes down to it, I agree. I think there is a 0% chance at a not guilty verdict here. Literally 0. You can give your percentages after. 0% chance that there is a not guilty verdict. I think there's about a 1 to 5% chance of a hung jury. And then I would say, with the percentages that are left, I would say 70-30 for murder 1. Like a higher percentage chance of M1 than M2 personally, because I think these facts are so shocking and the jury is really going to hate him. And you have the fact that he used his kids in this, he made his kids lie. The way they found it is because it synced with his kid's iPad. He was taking his kids shopping, looking in the camera, fixing his hair and smiling. And the way he acted afterwards, I think they're going to hate this guy. I think that there's a higher chance of M1 than M2. I think there's a very small percentage chance of a hung jury. I think there's no chance at a not guilty verdict. What do you think? I never buy as many things from as many different places as I do during the holidays. So it opens up more opportunities for more scams and fraud and people trying to steal my personal information. Well, today's sponsor, Cash App, is a huge help with that when you're buying everything for the holidays. The holidays are all about finding the perfect gift, but this time of year, not every deal is actually what it seems. Scammers are getting more and more creative to trick people into sharing their payment info through methods like fake shopping sites and giveaways that are too good to be true. Luckily, Cash App's 24/7 fraud monitoring helps direct and alert you for unusual card activity should someone gain access to your card, so you can act fast if something seems off. You can also lock or unlock your Cash App card instantly right from the app for extra control and peace of mind. Stay one step ahead of the scams this season and keep your money secure with Cash App. For a limited time only, new Cash App customers can use our exclusive code to earn some additional cash. For real, just download Cash App, use our exclusive referral code SECURE10 in your profile, send $5 to a friend within 14 days, and you'll get $10 dropped right into your account. Terms apply. That's money. That's Cash App. Cash App is a financial services platform, not a bank. Banking services provided by Cash App's bank partners. Prepaid debit cards issued by Sutton Bank, member FDIC. Promotions provided by Cash App, a Block Inc. brand. Visit cash.app/legal/podcast for full disclosures.
Well, I mean, let's say he's disgusting. He is. The guys like Jack the Ripper. I mean, these facts are just make you sick. It's going to make the jury sick.
The defense attorney literally kept having to admit to that in the closing argument.
I know. So it just makes you sick. So they're not going to let him walk out the door. That's no. So there's going to be a conviction.
Yeah.
Now I think I'd go 50-50 on murder on M1 and M2.
Okay.
I think there's an equal chance either way on this. If I were on the jury.
Yeah, that was going to be my last question: is what would you vote? Because I already told everybody what I would vote, but what would you vote?
M2. If I was on the jury, I don't think they proved beyond a reasonable doubt the premeditation. Not because I don't think he did premeditation. I think he was premeditated. However, they didn't prove it. They really had no evidence.
It's not motive.
To prove it.
It's not like I don't have to know his exact steps and whereabouts, but they do have to prove that beyond a reasonable doubt. I don't think they did. So yeah, I'd push hard for M2.
I think the people that are going to vote M1 on that jury are just so disgusted with this guy and they hate him so much that they just can't see anything else. They're blinded by the facts of the case.
And I think that if they come down to it and like there's a couple people that said we're never voting M1, that they'd be like, okay, fine, we'll vote M2 then to split the baby. So yeah, I think so too. I was trying to think if there's anything else.
Oh, you didn't ask me about her. Did I give her a grade? You didn't ask me about her grade.
What grade do you give the prosecutor?
Great. I would give and I'm not being consistent with you, but I give her a B as well. I know you gave her a B. I'd give her a B as well. I think she did a credible job in her closing argument. Again, not exciting, not theatrical, but credible. And that's all a prosecutor has to be, is credible. That's what people look to prosecutors to be.
I don't say this a lot. Okay. And I don't like to try to brag or anything. If I had this case, the closing would have been an A+. I mean, could you just imagine prosecuting this case? Just list search term after search term. And then you tell the jury what he was thinking when he searched that. That's what closing arguments are. You want to know what he was thinking when he searched this? I mean, this case could have been, they really could have just crushed this in my opinion. And instead, I think they just did enough and worked the ball down the field and got 3 yards in a cloud of dust, kind of how they say that. Right. But, I mean, this case, this guy, I think you could have had a 1 hour conviction on this case if you prosecuted it right, personally. But I do think intent was difficult for them to get around. But I do think there were some nuggets that they could have explained and dug into more that could have gotten there. Yeah.
I agree with you. They could have. But I said that they had the facts, and I guess they didn't think they had to do a great closing argument. You know what I mean? They had the facts.
Yeah. Well, Monday night, we are doing our office Christmas party, so we're not going to be able to react to a verdict if it happens Monday night. But if it happens Monday during the day, early or afternoon, we'll come on.
Do it for the party.
Yeah, live stream from the Sergeant Trigo's Christmas party, our immediate reactions to the verdict. But yeah, so that's week 2. There will not be a week 3, but we will do a verdict reaction of some sort. Thank you guys for joining us. Make sure you hit that like button. Dad, thanks for joining me as always. But that's all we got. Until next time, we are out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe.
You can also follow us on Instagram, X, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast featuring new episodes every week. And if you have a case that you want to personally talk to us about in your life, if it's a personal injury case, wrongful death, catastrophic injury, car accident, truck accident, or slip and fall case, please email us at lawyeryouknow@gmail.com.
And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.